Your Honor, the defense firmly believes that the evidence presented does not meet the threshold for conviction.
Thursday morning, 10:30 a.m. Providence Municipal Court, 20-2-year-old. Victoria Romano struts into Judge Frank Caprio's courtroom like she owns the entire judicial system. Her $4,000 Hermes bag bounces against her hip with each confident step. Her Cartier diamond bracelet catches the fluorescent lights as she waves dismissively at court staff. Her designer heels click against the marble floor with the rhythm of someone who has never been told no by anyone who mattered. But it's not her expensive accessories that command attention. It's her attitude. Victoria carries herself with the toxic arrogance of someone whose father sits on the Senate Judiciary Committee and whose family name has always been a get-out-of-jail-free card. Following reluctantly behind her is Thomas Whitman, one of the most expensive defense attorneys in New England, a man whose usual confidence appears shaken. He keeps checking his Rolex and whispering urgent instructions that Victoria completely ignores. You're wondering why this senator's daughter is in Judge Caprio's courtroom today. Last Saturday night, Victoria was driving her father's government sedan through downtown Providence at 2 a.m. when she decided traffic lights were optional. After running 3 red lights while live streaming, she crashed into a parked police cruiser at 55 miles per hour in a 25 miles per hour zone. When officers Martinez and Johnson approached the scene, Victoria didn't apologize. Instead, she stepped out of the vehicle and delivered the line that would seal her fate. Do you idiots know who my father is? You can't touch me. I'm Senator Romano's daughter. When Officer Martinez attempted to administer a breathalyzer test, Victoria laughed and said, I don't submit to tests from people who work for my family. My father funds your paychecks. When the officers explained she was under arrest, Victoria's response revealed her entitlement. You can't arrest me. I have diplomatic immunity. My father will have your badges before morning. The entire encounter was captured on body camera footage that went viral. Victoria threatening police officers, claiming immunity she doesn't possess, and repeatedly stating that her father's position makes her untouchable. Today, Victoria stands before Judge Frank Caprio, expecting her connections to Macathis disappear. What she doesn't realize is that Judge Caprio has reviewed the body camera footage and is prepared to deliver a lesson about accountability that will change her life forever. As today's hearing unfolds, this entitled senator's daughter will demonstrate such shocking disrespect that she will literally be removed from the courtroom in handcuffs. When Victoria tells Judge Caprio he can't touch her because of her father's Senate position, she will learn that in America's courts, justice is blind to political connections. What you're about to witness isn't just a court hearing. It's a masterclass in how privilege meets accountability. When arrogance collides with justice. Hit that like button and prepare to see entitlement. Meet reality when a senator's daughter discovers that daddy's influence ends at the courthouse door. The bailiff announces the state of Rhode Island versus Victoria Ann Romano. Charges: driving under the influence, destruction of government property, resisting arrest, threatening law enforcement officers. Victoria saunters to the defendant's table with the confidence of someone attending a charity gala where she's the guest of honor. She doesn't acknowledge Judge Caprio, the court staff, or even her own attorney. Instead, she pulls out her phone and begins taking selfies in the courtroom. Judge Caprio looks up from his papers with characteristic dignity and patience. Good morning, Miss Romano. Victoria doesn't respond. She's too busy adjusting her phone, angled to capture the perfect courtroom selfie for her Instagram story. Ms. Romano, I'm speaking to you. Victoria glances up with obvious irritation, as if Judge Caprio has rudely interrupted something important. Oh, hi. Sorry, I was just documenting this whole circus for my followers. They find government incompetence really entertaining. She waves her phone toward Judge Caprio. You don't mind if I live stream this, do you? My audience loves behind the scenes content from their tax dollars at work. Judge Caprio's voice becomes firm but controlled. Ms. Romano, you're in a court of law facing serious criminal charges. Please put your phone away and show proper respect for these proceedings. Victoria rolls her eyes dramatically and slides her phone into her purse with theatrical reluctance. Fine, but this better be quick. I have a spa appointment at noon, and they don't reschedule for government employees. The casual dismissal of court proceedings as inferior to her body routine sends ripples of shock through the gallery. Judge Caprio studies the police report. Ms. Romano, according to officers Martinez and Johnson, you were driving under the influence when you crashed into a police cruiser at 55 miles per hour. Victoria's explanation shows her lack of accountability. Your Honor, I wasn't drunk. I had maybe 2 cocktails at a charity event. I was completely in control when this unfortunate accident occurred. Ms. Romano, you refused to take a breathalyzer test. Victoria's response reveals her sense of entitlement. Your Honor, I don't submit to roadside testing by local officers. My familia has diplomatic status through my father's Senate position. Judge Caprio's voice becomes more pointed. Ms. Romano, senators' family members don't have diplomatic immunity. Victoria looks genuinely shocked. Your Honor, that can't be right. My father sits on the Senate Judiciary Committee. He literally writes the laws. We absolutely have special status. Judge Caprio reads from the police report. Ms. Romano, when Officer Martinez attempted to arrest you, you stated, "You can't touch me." I'm Senator Romano's daughter. Explain that statement. Victoria's response shows her complete inability to understand equal treatment. Your Honor, I was simply explaining the legal reality. Local police don't have a jurisdiction over Senate families. It's not personal. It's just how the system works. You believe local police can't arrest senators' children? Victoria nods with alarming confidence. Absolutely, Your Honor. Federal officials and their families are protected from local harassment. It's called separation of powers. Judge Caprio's voice becomes sharper. Ms. Romano, you threatened the officers' jobs because they were doing their job? Victoria waves dismissively. Your Honor, I wasn't threatening anyone. I was educating them about government theory. Sometimes local officers need reminders about chain of command. The arrogance of treating police officers like personal servants leaves the courtroom stunned. Judge Caprio continues reading. Ms. Romano, you told Officer Johnson, I have diplomatic immunity. Do you understand what diplomatic immunity actually means? Victoria's response shows her complete ignorance. Your Honor, diplomatic immunity means government officials and their families can't be arrested by people who rank below them. It's basic civics. Judge Caprio's voice becomes educational. Ms. Romano, diplomatic immunity applies only to accredited foreign diplomats. It has nothing to do with senators. Victoria looks confused and annoyed. Your Honor, that doesn't sound right. My father has immunity from prosecution. That protection extends to family members. Judge Caprio studies the case file more carefully. Ms. Romano, when you crashed into the police cruiser, what was your immediate concern? Victoria's answer reveals her complete lack of empathy. Your Honor, my immediate concern was that this incident might be photographed or recorded and damage my social media presence. I work very hard to maintain my personal brand. You weren't concerned about potential injuries or property damage? Victoria shrugs with infuriating nonchalance. Your Honor, nobody was hurt, and the car damage is covered by government insurance. These situations get resolved through proper channels without involving local courts. Judge Caprio's voice becomes more challenging. Ms. Romano, you destroyed a police cruiser that serves the public safety of this community. Victoria's response shows her complete disconnection from public service. Your Honor, police departments have vehicle budgets for exactly these situations. They'll get a newer car out of this, so if anything, I did them a favor by helping them upgrade their fleet. This is the moment when Victoria makes her most catastrophic mistake. Instead of showing any remorse or respect, she decides to assert her privilege directly. Your Honor, I appreciate that you have a job to do, but I think we both know this case is going to be resolved through appropriate federal channels. My father's office is already handling this situation diplomatically. Judge. Caprio's voice becomes deadly quiet. Ms. Romano, explain what you mean by appropriate federal channels. Victoria leans forward with growing confidence, apparently believing she's about to end this proceeding with superior legal knowledge. Your Honor, Senator Romano's office has contacted the Department of Justice regarding this local overreach. Federal prosecutors will handle this matter if any charges are warranted, which they're not. Judge Caprio's expression hardens. Ms. Romano, are you telling this court that your father is intervening in your criminal case? Victoria nods enthusiastically, apparently not understanding the implications. Exactly, Your Honor. That's how these situations work. Local courts don't have a jurisdiction over federal officials' families when they're traveling on government business. You were on government business at 2 a.m. on Saturday? This courtroom case begins quietly, without shouting, without theatrics, and without accusations of wrongdoing in the traditional sense. There is no crime here, no violence, no malicious intent. What stands before the court instead is something far more common and far more difficult to resolve. A collision between legal ownership and human survival. The defendant is a 68-year-old woman who has lived most of her life without incident. Her record as a renter is long and stable. She describes decades of consistent rent payments, long-term leases, and a history that contradicts the image of neglect or irresponsibility. This is important to her because she believes character should matter. She believes history should matter. She believes that who she has been should influence what happens to her now. But courts do not operate on who someone has been. They operate on what exists at the moment the case is filed. The turning point in her life, as she explains, was illness. COVID did not pass through her life briefly. It stayed. Long COVID dismantled her ability to work, earn, and function independently. At an age where recovery is uncertain and opportunities are limited, illness became permanent. Income disappeared. Savings vanished. What followed was not a single failure, but a chain reaction. Missed payments, growing debt, and increasing dependence on systems that did not respond in time. When she speaks, she does not deny the debt. This is crucial. She does not argue that rent is not owed. She does not dispute the landlord's ownership. Instead, she focuses on circumstances, medical vulnerability, disability, and the absence of safe alternative housing. Her goal is not to defeat the law, but to slow it. The judge listens carefully, but his role is narrowly defined. This is a termination action. That designation changes everything. The court is not deciding fairness. It is deciding possession. Without a written lease, the legal framework becomes stark. The landlord's right to reclaim the property is clear. The tenant's continued presence is permissive, not protected. The defendant attempts to introduce a layer of complexity, medical accommodation. She explains that this home has been modified for her condition. Wireless exposure reduced, utilities adjusted, agreements made verbally with the landlord's knowledge. This is not merely a place to live. It is a controlled environment that allows her to function. Leaving does not simply mean relocating. It means risking further health deterioration. But again, the law does not move with the same flexibility as human need. Verbal agreements do not override ownership rights. Medical hardship does not create tenancy protection unless explicitly codified. The judge acknowledges her statements, but does not treat them as legal barriers. His restraint is not indifference. It is limitation. As the discussion turns to financial assistance, the emotional center of the case begins to fracture. The defendant speaks of agencies, applications, appointments, and pending responses. In her mind, help is delayed but possible. The judge responds with arithmetic. Even if assistance arrives at maximum capacity, it does not erase the debt. Thousands of dollars remain outstanding. This is the moment where optimism collapses under calculation. When the judge states that this is no longer a question of if she will have to leave, but when, the tone of the hearing shifts permanently. This sentence transforms the courtroom from a space of argument into a space of negotiation. The outcome is decided. Only the timeline remains. The defendant understands this instantly. Her language changes. She stops explaining the past and starts discussing logistics. Packing, physical limitations, lack of transportation, the absence of family support, the approaching holidays. Each detail is not offered as leverage, but as reality. She is not asking to stay forever. She is asking for time. The landlord responds with her own truth. She is not wealthy. She depends on rental income. She has waited. She has hoped. She has reached her limit. This is not cruelty. It is exhaustion. The judge recognizes this. He must balance two collapsing margins, knowing that any decision harms someone. In this moment, the judge exercises the only discretion the law allows him. He grants possession to the landlord because he must, but he delays enforcement. The writ will not issue immediately. January 31st becomes the boundary. Not justice, not rescue, but delay. Delay is not insignificant. Delay means planning instead of panic. It means the difference between being removed and leaving on one's own terms. It is the last form of dignity the court can offer. The case does not end with relief. It ends with structure. Monetary claims are postponed. Access issues are clarified. Rules replace conflict. The system does what it is designed to do: impose order where chaos threatens to take over. And yet, as the courtroom empties, the truth remains unchanged. The defendant will lose her home. No law was broken in spirit. No voice was ignored. No one acted maliciously. And still, the outcome is displacement. As the hearing moves forward, the emotional distance between what the defendant needs and what the court can provide becomes increasingly clear. This is not because the judge lacks empathy, but because empathy alone cannot rewrite legal boundaries. Courts are not designed to absorb suffering. They are designed to contain conflict. And when suffering itself becomes the conflict, containment feels like abandonment. The defendant continues to speak from a place of lived experience rather than legal positioning. She does not structure her words around statutes, notices, or procedural defects. Instead, she narrates decline, illness, isolation, dependence. Her language reflects someone who has already lost control of most areas of life and is desperately trying to preserve the last one that still feels tangible: her home. What she is really asking the court to do is to treat her situation as exceptional. Not morally exceptional, but structurally exceptional. She wants the judge to see that this is not a typical non-payment case. She wants him to acknowledge that the home itself has become a medical necessity. This is why she emphasizes the modifications: the reduced wireless exposure, the specific conditions that cannot easily be replicated elsewhere. In her mind, moving is not just relocation, it is medical risk. But the law does not recognize uniqueness unless it is formally documented and protected. The judge cannot elevate verbal agreements into enforceable rights. He cannot convert medical hardship into tenancy without statutory backing. Every time the defendant expands the story, the judge narrows the lens. This is not dismissal, it is function. The judge's questions are precise, almost clinical. How much is owed? What assistance might cover? What remains unpaid? He is not interrogating her credibility. He is calculating feasibility. Courts do not operate on hope. They operate on likelihood. And the likelihood, as the numbers reveal, is grim. When the judge explains that even full agency assistance would leave a substantial balance unpaid, he is not rejecting her efforts. He is acknowledging their insufficiency. This is a painful distinction. The defendant hears rejection. The judge intends realism. Between those two interpretations lies the emotional rupture of the case. At this point, the courtroom dynamic subtly changes. The defendant's tone softens. Her sentences grow longer, less structured. This is the sound of someone processing loss in real time. She is no longer presenting information. She is adjusting expectations. The possibility of staying dissolves. The question becomes how to leave without being destroyed in the process. The judge's statement that this is a matter of when, not if, is delivered without emphasis. That is what makes it powerful. There is no raised voice, no dramatic pause, just clarity. This is how courts close doors, quietly. From this moment forward, the defendant's strategy becomes survival-oriented. She speaks about logistics rather than legality, packing assistance, physical limitations, the absence of transportation, the holidays. These details are not excuses. They are constraints. She is mapping the practical reality of displacement, hoping the court will allow enough time to navigate it. The landlord's response introduces a parallel narrative. She is not portrayed as predatory or uncaring. She is elderly herself, dependent on rental income, burdened by years of unpaid rent. Her words reflect exhaustion rather than anger. She frames her position not as punishment, but as inability to continue carrying someone else's loss. This matters. The judge must consider hardship on both sides. Even when one hardship appears more visible. The judge's role here is not to choose the good party. It is to restore balance within legal boundaries. And balance, in this case, means possession with delay. He grants the landlord what the law guarantees, but he controls how and when it is enforced. This is the narrow space where compassion can exist without undermining precedent. January 31st becomes the court's compromise. Not the end of January, not immediate removal. A fixed date, firm but not abrupt. This date is not arbitrary. It accounts for holidays, logistics, and human limitation. It also respects the landlord's right to reclaim control. The judge is not choosing sides. He is managing consequences. By separating possession from monetary judgment, the judge further reduces harm. He recognizes that assessing damages before vacancy would be speculative. He ensures inspection happens after departure. This protects both parties. It prevents inflated claims. It preserves procedural fairness. These details matter because they show the system working as intended, even when the outcome is harsh. A final conflict arises over access to the property. The landlord claims obstruction. The tenant claims fear and illness. This is a classic escalation point in housing disputes. The judge resolves it not emotionally, but structurally. 48 hours notice, clear permission, defined boundaries. Process replaces confrontation. This moment is important because it reveals how courts neutralize tension. They do not validate competing narratives. They impose rules that make narratives irrelevant. Once rules are clear, compliance becomes measurable. Conflict loses oxygen. As the hearing draws to a close, the defendant thanks the judge. This is not gratitude for the decision. It is gratitude for acknowledgement. for being allowed to speak fully, for being treated as a person rather than a case number. In systems that often feel impersonal, this matters deeply to people who feel erased. Judge responds professionally and ends the session. There is no dramatic resolution, no moral victory. The courtroom simply transitions to the next matter. This is how institutional processes operate. They absorb human crises one at a time, without pause. What remains unresolved is not the legal question. That has been answered. What remains unresolved is the human aftermath. The court does not follow the defendant home. It does not see the packing, the exhaustion, the uncertainty, the fear of what comes next. The law ends where enforcement begins. This case exposes a fundamental truth about justice systems. They are not designed to prevent loss. They are designed to regulate it. When resources are insufficient and protections are absent, regulation feels like indifference. Even when it is not, the judge did not fail this defendant. The law did not malfunction. The landlord did not act illegally. And still, the result is displacement. This is not a story of wrongdoing. It is a story of limits. As the courtroom empties and the official proceedings conclude, what remains is not merely legal documentation, but the profound human cost embedded within those documents. For the defendant, the hearing was never about abstract law. It was about survival, dignity, and continuity of life. Each word she spoke, each reference to medical conditions or decades of tenancy, was a plea to be seen as more than a ledger entry. The court, constrained by statute and precedent, cannot create solutions. It can only measure compliance. The defendant's narrative highlights the stark contrast between systemic logic and human reality. Courts and landlords operate on rules, deadlines, and financial obligations. Tenants, particularly those experiencing long-term illness, disability, or social isolation, operate on lived experience, personal capacity, and hope. This intersection is where tension becomes almost inevitable. Even when both parties act in good faith, the structure of law ensures that one side experiences loss. In this case, loss is multifaceted. The defendant faces displacement, logistical obstacles, health risks, and psychological strain. Her references to long COVID, electromagnetic sensitivity, and PTSD are not embellishments. They are barriers to a feasible relocation. Each illness limits mobility. Each condition requires specific environmental adjustments, and each limitation compounds the practical difficulty of moving within the court's mandated time frame. From the outside, eviction may appear simple: pay or leave. From the inside, it is a labyrinth of constraints with no easy exit. The judge's decisions, though neutral, become a form of intervention. By delaying the writ until January 31st, he allows the defendant space to organize, to pack, to negotiate assistance, and to retain some measure of control. This delay is more than procedural. It is the only buffer between compliance and catastrophe. Yet even this buffer cannot eliminate the fundamental conflict. The legal right to possession and the human right to stability are in collision. The landlord's perspective provides further insight into systemic limitations. She is not vindictive. She is exhausted. For years, she attempted voluntary solutions, hoping the defendant could stabilize and pay arrears. Those efforts were unsuccessful. The law empowers her to reclaim her property, but human compassion delayed. Enforcement. This dynamic, goodwill constrained by law, is common in housing disputes. It is also rarely acknowledged in public discourse, where narratives often simplify conflict into good versus evil. The financial dimension amplifies the tension. Despite applications for assistance, systemic gaps prevent full coverage. Agencies have limited resources, and their support, while helpful, cannot erase accumulated debt. The judge's arithmetic is not punitive. It is inevitable. Even maximum assistance leaves a significant shortfall, making partial relief insufficient. Here, law, finance, and health intersect to produce an outcome that satisfies no party fully. The system functions correctly, yet humans suffer nonetheless. The procedural management of the case, including separation of possession from monetary, judgment, and the 48-hour notice for mechanical room access, exemplifies how courts attempt to mediate conflict without creating injustice. By sequencing enforcement and clearly defining obligations, the court minimizes immediate confrontation while preserving rights. These measures are subtle, almost invisible, but they shape real experiences. The defendant is forced to comply, yet she retains procedural dignity. The landlord regains access, yet she does not act extra-legally. The judge maintains authority, yet mitigates unnecessary harm. This balancing act is the unseen work of judicial discretion. Psychologically, the hearing exposes the cumulative effect of systemic stress. For the defendant, repeated interruptions, requests for documentation, and legal technicalities function as constant microstressors. Each requirement reinforces dependency, vulnerability, and uncertainty. Her narrative reflects frustration not with any individual, but with the structure of authority itself, a system that acknowledges suffering but cannot eliminate it. The judge's measured interjections, though procedurally sound, highlight the constraints imposed by law on human compassion. The implications extend beyond this single tenancy. The case reflects broader societal patterns: the difficulty of securing housing for medically vulnerable individuals, the gaps in assistance programs, and the tension between property rights and human need. It illustrates the ways legal systems mediate conflict while simultaneously exposing human vulnerability. Each decision, though technically correct, carries consequences that ripple far beyond the courtroom. Finally, the case reveals a philosophical dimension of justice. Law provides order, not salvation. Rights and obligations are enforced according to statute, not necessity. Compassion, when it exists, is procedural, not unlimited. For individuals like this defendant, justice may appear indifferent, yet it is the framework that allows society to function predictably. This paradox, where lawful outcomes produce human hardship, is central to understanding the modern judicial system. As the hearing concludes, the court record captures only one layer of the story: possession granted, monetary judgment deferred, procedural instructions provided. What remains invisible are the hours of planning, the nights of anxiety, and the weight of dislocation borne by the defendant. The human story continues beyond the courtroom walls, unfolding in real time, shaped by the decisions made here. In this light, the case becomes more than a tenancy dispute. It is a lens into the complex interplay of law, human need, and societal structure. It asks an uncomfortable question: can systems designed to regulate behavior adequately address human vulnerability? The courtroom provides clarity and order, yet the human experience, fear, loss, endurance, exists in parallel, largely unmitigated,